Okay, I think that's enough time. Good morning, everyone. Let me just put on my camera so that you can see me. Good morning, good morning, good morning, and good morning to those who are joining us right now. My name is Nelly Wainaina. I will be taking you through this webinar. I'll be your moderator for today. And I hope you're as excited as I am as we venture into this not very well-known topic, but as we discuss what trusts are, we look at it in depth. I'm very, very excited to have each and every one of you join us on this. If you're in Nairobi, it's a bit cold, but the sun seems to be coming out, and I guess that's a very, very good sign. So thank you, each and every one of you, for joining. Thank you for keeping time. Some of you are here even before 10, so we really, really appreciate that, and I'm taking it as a sign that everyone's very, very ready to join us for today. So a few housekeeping rules. Any questions that you may have in the course of the presentation, please raise them in the chat section. If at any point in time after you have a question during, when Stella is doing her presentation, raise it in the conversation portion of this Teams system, and we'll be able to pick it up once she's done with her conversation. After we have the presentation, we will have a Q&A session, so don't worry, you will also be able to have an opportunity to ask your questions directly to Stella and any concerns or questions that you may have about what you will present. So also your mics will be muted for the duration of the presentation, and please ensure that they remain muted during the presentation to prevent feedback. And then once we're doing the verbal Q&A, we will enable you to unmute yourself and ask your questions. So once again, thank you so much for joining us. Stella, if you can raise your presentation as I do a brief introduction. So as Stella does her presentation, I think it's always wonderful to start with a word of prayer. And so that I don't ambush anyone, I'll just ask Monica Shilwatso. Please just give us a quick prayer as we start off this particular webinar.
Thank you, Nelly. Good morning, everyone.
Thank you.
Let us pray. Heavenly Father, we come before you this day with thanksgiving, with praises, with glory and honor. We want to thank you in a special way for the gift of life. We are not taking it for granted that you have enabled us to face this new day. We pray, Heavenly Father, that as we set to begin with this webinar, where we are going to learn something, that you will be with us. You'll be with us in this meeting. You will allow us to participate fully, ask questions where we can, and be able to understand on matters of trust. We want to thank you for all those who are represented here, Heavenly Father, together with their families. Thank you for being with them in whatever that they do. Continue seeing them through. We pray that you may be able to be with us during this day, everything that we do, that it may be a blessing from you. We pray this short prayer, trusting and believing in Jesus Christ, our Savior. Amen.
Amen and amen. Thank you so much, Monica. Thank you for the prayer. And now I will do a brief introduction as to what exactly we're going to be presenting today, what we're going to be talking about. So today we're going to be looking at a webinar specifically for trusts or trust funds. And our presenter today, Stella, will be taking us through what trusts are and exactly how they are beneficial to us, not just as individuals, but as trustees in our various schemes, as human resource personnel, and how exactly they would play out in your life. We are very, very honored to have each and every one of you, the number of you that have joined. And if you feel that someone in your circle of friends, in your circle of family needs to hear this, we will be copy pasting the invite to the conversation section, and you can quickly forward it to a friend. So feel free to have anybody in the office, anybody at home with you listening, because this is information that needs to get out there. This is information that people need to know. They say knowledge is power. So let us ensure that we empower each and every single person who is around us. Okay. So now, without further ado, I am not the star of today's show. Rather, our presenter for the day is. So allow me to introduce her. Ladies and gentlemen, in the Teams meeting, because you can't say in the auditorium, or you cannot say in the room. So ladies and gentlemen online, Our presenter today is Stella Musembi-Ojango. She is a partner at Kikera Gama Advocates and heads the Nairobi office. She has a distinguished track record in delivering advice on real estate projects, including property acquisition, requisite approvals, development financing, and contract documents. She also advises financial institutions on matters of risk management, corporate governance, and legal compliance. She also has a large amount of expertise in intellectual property, cybersecurity law, and pension law. She has drafted and reviewed various trust deed and rules for schemes and issued legal advisories on various retirement benefit related issues. Today, she comes to us as an expert in matters of estate planning and trust, an area that she has helped develop, that she has a great interest in, and I'm sure she'll be sharing a large amount of that knowledge with us today. She has a Bachelor of Law degree from Moi University and a diploma from the Kenya School of Law. She is currently pursuing her master's degree in environmental law and has undertaken the Trustee Development Program Training, the TDPK. For those of you who are trustees in this particular meeting, I'm sure you know that that is not a very easy course, so she has done it as well. She's a member of the Law Society of Kenya and an advocate in the High Courts. Okay. So she's passionate about all things environment, estate planning. She loves the outdoors. And actually, I will ask her to tell us a bit more about what she loves about the outdoors. Stella, thank you so much for joining us. Thank you for taking the time. I hand over these wonderful people to you for you to share a bit of your knowledge on this matter.
Good morning, ladies and gentlemen. Thank you, Nelly, for that wonderful introduction. I am humbled actually just hear that all that is me. And indeed, I do like the outdoors. I enjoy taking walks at the Karura Forest. And I'm even a mountain climber. I've done Mount Kenya 2 times. So away from that, I know today, I'd like to thank Octagon for this opportunity to make this presentation. And I would like to thank all the ladies and gentlemen who have joined quite on time to listen to me. I hope I will do service, and I hope that you will learn and take as much home as possible. And I welcome all questions. So indeed, the main topic is trust, but allow me to start at the very beginning, and that is matters estate planning, and that is why you see the presentation headed as such. But indeed, after that preamble of estate planning, we will move on to the main topic, which is matters trust. So my name is Stella Musembi-Ojango. I work with the firm known as Kikera Gama Advocates, and we are delighted to be a team of advocates able to make this presentation to you today. Thank you. So I will move on straight into the presentation. So what then are our objectives today? So number one is to know your estate. As a trustee of a pension scheme, as an individual, as a Kenyan, if you're going to plan your estate, the first thing is you need to know your estate. You need to know who your dependents are, and then you need to avoid having an estate that is not well planned for. So you know your estate, you know who your dependents are, then you need to plan for that estate. And of course, the major way of planning has been the probate route, which is where you draft a will. And then how do you handle property that is in multiple jurisdictions? And then what will be our takeaway? And in here, as you plan your estate, we will talk about trust. So here, we are looking at a family, and the father to the young gentleman and lady is asking, am I sure I can trust you not to fight over my money when I am gone? And of course, they confirm to him that indeed, they will not fight over his estate. But you can see what they are holding behind their hands, waiting to get their hand on the estate and on the money that is held by this particular individual. So this particular individual needs to plan for his estate if these children of his will have a life that is orderly and will manage his estate long after he's gone. So in an instance where the estate is not managed, this is what happens. Long after the testator, long after the settler, long after the individual is gone, it doesn't even have to be long. It can even be long or shortly thereafter. This is what happens when an estate is not planned for. So what then are the assets that need to be planned for in an estate? So number one, as an individual, you've got to take stock of your property. And when we talk about property, we talk about movable assets. And what are these movable assets? They can be your bank account balances. What is in your bank accounts? Now we even have M-Pesa accounts. We have shares in different companies. We even have motor vehicles that we own in our name. So all these are movable assets that we need to plan for as individuals. And then immovable assets. And these are the ones we see a lot of fighting and wrangling over. Apartments, houses, mansionettes, bungalows, land. All these are assets that need to be planned for very well. And in planning for these assets, you need to document, to list them properly, because what happens, you will find that a testator, an individual who wants to plan for their asset or for their estate, if they have not listed all their assets, some of them are left unplanned for. So the first thing is to always list your assets, both movable and immovable assets. With that list of assets, then we can proceed on to plan for the estate of that particular individual. Then as we're listing our assets, it's important to list our dependents. As an individual, who then are your dependents? A dependent can be a wife or wives, or even a former wife can also be a dependent. So, and then the next set of dependents is children. And when you talk about children, the law of succession, the law of succession in Kenya identifies or recognizes both male and female. And that is regardless of their age and of course their gender. So you cannot plan for your estate or plan for your dependents and only bequeath or give your estate to only the male or to only the older ones and not the younger ones. These are reasons why wills become challenged. So it's good to plan for to list your dependents, knowing that all your children are dependents for all intents and purposes in terms of inheriting from you as an individual. And then the next thing is children taken into the family. Especially in Africa, we take in our relatives' children. Say, God forbid, a sister passes on, you find the brothers, the other sisters take in their children. So if these children are taken into a family, they then become your dependents, whether or not they're your own biological children. They then become your dependents. So you've got to plan for them as well. Such children can challenge a will if they're not provided for in that particular document, because they have been relying and living in that particular home and relying on the process of that particular home for their schooling, for their feeding. So they're dependents for all intents and purpose. And then siblings and half siblings being maintained. If you have your brothers and your sisters living with you, and you're probably paying for their schooling, you're probably maintaining them in one way or the other. To that extent, they are your dependents, and they can claim a part or a portion of your assets. And even husbands, if being maintained by their wives, they are dependents for all intents and purposes. And another set of dependents who are not in the first line of dependence are your own parents. Parents who are depending on you, whom you are sustaining, whom you are, maintaining. In their lifetime, they also become your dependents, and you need to provide for them. And that's what I provided up here: parents, step-parents, grandparents, grandchildren, stepchildren. All of these are become your dependents. So it's important to provide for them, especially if you have been maintaining them in your lifetime. Then the other thing is, now you have identified your assets, you have listed them, you have identified your dependents, and you have listed them. So the next thing is now preparing and managing your asset base. So how to go about doing this? One of the estate planning strategies that we recommend as advocates, and this is always a starting point for any individual, is what we're calling probate. And probate is simply drafting a will, having a will that you then come up with as the testator. A testator is a person who signs off a will, is the owner of the will, the person who came up with the will, the person who distributes their property. That person is known as a testator. So you then become a testator and draft a will, or have an advocate assist you in drafting a will, wherein you distribute your property as you wish. Of course, we are saying the alternatives to probate, and we will get to that. That is what we are looking to discuss today. that is matters trust. But at this particular level, we want to start at the very bare minimum, having a will. So we have individuals who prepare a will, who are convinced that there is need to prepare a will. And I've said that individual who makes a will is called a testator. And then it is said that their estate is tested. Their estate is well provided for. So as a testator, what are your rights? You decide who gets what. So you have your list of dependents and you have your list of assets. You have a right to decide who gets what, who to exclude, who to manage, and your last respect. Where do you want to be buried? Where do you want to have your body interred as a last respect? What do you want to happen even in that ceremony? So all these are things that you can provide. And then there are those of us who do not prepare a will. We are saying such individuals are said to have died intestate. And then for such individual, what happens? The government decides for them. They may be asset and control wrangle. Likely, where you have no will, there's a very high likelihood of asset control wrangles. And then relationship tussles, especially where we've spoken about wives and wives. Especially in the instance of wives, here there'll definitely be some serious relationship tussles, because now with wives, there are then children and stepchildren. So dying intestate or without a will is highly not recommended. It is important to provide for our estate, because when we make a will as a testator, we have a lot of liberty in determining who manages our estate, who gets what, who is excluded, and for what reason. But remember, as you're excluding the dependents, the first list of dependents that I mentioned to you are depending on you. It's highly recommended that you provide something for them to avoid wrangle. And then where do you want your body interred? So creating a will, preparing a will gives you a lot of control over your own estate. So here we want to look at benefits of, there are two forms of will. You can have an oral will or a written will. So when you have an oral will, number one, an oral will is valid in law. It is not invalid. So both wills are valid, both oral and written will. Executor, an oral will can have an executor, or it may not have an executor of that particular will. And then the next thing is the witnesses. Both wills, both oral will and written will require to have a minimum of 2 witnesses. And these witnesses should not be beneficiaries of the estate, should not be beneficiaries of the testator's estate. So that is very key to note. As a testator, your oral will, both oral and written will, the witnesses should not be your beneficiary. And of course, it's got to be of a sound mind. And then the other thing that I've got to mention about an oral will, it's time validity. I know I've skipped fraud, I'll come back to fraud. So, but time validity. An oral will is valid for only 3 months. And you find oral wills are mostly made when someone is very sick, they're probably on their deathbed, and they realize they don't have a will. So they call a few witnesses, they call a few friends, and they tell them, I wish A, B, C, D done with my estate. So that will is only valid for 3 months. That means that the testator of that will needs to have passed on within a period of 3 months if that will is going to be valid. If they pass on after, say, 6 months, that will is not valid. That oral will is not valid. There's an exception though. Section 7 of the Law of Succession Act says there's an exception for this active officers in active service in the armed forces or merchant marine. So they're saying, so long as you're in active service in the armed forces or as a merchant marine, your oral will remains valid if you die within that period when you're in active service. So that is the only exception for oral wills. But otherwise, oral wills are only valid for 3 months. So that's why we would recommend to steer away from oral wills and always prepare written wills. which have no timeline. Their time validity there is no timeline to say that this oral will expire at this time. Then in case of coercion, in case the testator is coerced, they have a gun onto their head when they are crafting their will. In case there is a mistake or fraud, that invalidates the will, both the oral and the written will. But that has got to be proved that indeed there was fraud, there was coercion, there was a serious mistake. That has got to be proved before that will is invalidated by a court of law. And then conflict between witnesses. If there's conflict between witnesses, especially for oral wills, if one witness says A and the other one says B, that property, let's say the property in Tusuru was given to beneficiary A, and the other one says that same property was given to beneficiary B, that will invalidate that will because it's an oral will. So what the witnesses listen to, or what the witnesses in an oral will hear, has got to be word for word. They cannot contradict each other. They cannot be conflict. But in case of conflict in written wills, that does not necessarily invalidate that will. And that's why we will highly recommend that wills are written as opposed to oral. Oral wills, we highly discourage oral wills. So let us look at an example of an estate of a gentleman who died testate. Intestate. Intestate means he did not have a will. He died intestate without a will. And we are looking at the estate of one Mr. Mliu Koinange. He was actually a cabinet secretary or a minister, as they were then called, in the days of Mzee Jomo Kenyatta, our founding president. So this is what happened to his estate after he passed on. So the gentleman passed on sometime in 1981, and the family went on to file a case in court for distribution of his estate. Of course, in his case, he had about 4 wives. And you can see this case, judgment was entered in 2020. That is actually last year. So this case has been in court for more or less 19 years. And what happens for this period that a case is in court, because there is no will, is that there is wastage of assets. Some of those assets just waste away. And then some of the claimants, some of the people who will have benefited from this estate have actually passed on over time. So then there's death of claimants without having benefited from this estate. And what Justice Mchelule said is that one wishes that all Kenyans can get into a habit of planning their lives, and especially thinking about what will happen to their families and properties upon their death. It is not too much to ask that the planning be by way of writing wills. So this is one of the sentiments that the judge expressed. And you can tell that he had seen the wastage of the assets, the relationship breakage, or the relationship tussles of the family members. And this is what he said as a judge, that one will wish that Kenyans will get into the habit of planning their estates and writing wills. So definitely we highly recommend that this is definitely a starting point for any individual who wishes to plan for their estate. So we then look at what happens where there is intestacy, where there is no will, where a person has died with no will. So in case of intestacy, where there is no will, the surviving spouse has a life interest in the estate. And then absolute interest to children equally. And that is what the court said in this particular case, that the children have an interest in the estate equally. And then where there is no spouse, the children share out the estate equally. Where there is no spouse or children, then the estate is shared out to the father, the mother, the siblings, the half-siblings of the individuals, the family. So that particular individual was not married and he has since passed on and he had no children, then his estate is distributed to his siblings, to his relatives. And in case there's no parents, he has no relatives up to the 6th degree, then the estate devolves to the government. So this may not have been the wish of that particular individual. If only they had a will, probably they could have bequeathed that property, say, to a children's home, say, to a noble cause. But because they had no will, and they have no parents, and they have no relatives, then eventually that estate devolves to the government. So as we have been saying, as I have been saying, we highly encourage being tested, that is having a will, getting into the habit as Kenyans of having a will and planning for our estates right from the get-go. So I will, before I move on to the next option, the other options, a will can be revoked. A will can actually be revoked, but the grounds for revocation of a will are if in the event the testator during his lifetime wishes to amend the will. They have a right to amend the will, so they can revoke the old will and have a new will. In case the executors of that will pass on, that is a very good ground for revoking the will to appoint new executors. And who are executors? Executors are the people appointed by the testator to distribute his property. And these executors can be some of the beneficiaries or may not even be beneficiaries. So they're the ones who distribute his property as he wishes. So if they all pass on, and people have a mark, most of the time, 2 executors. If both of them pass on or one of them passes on, it can be a good ground for revoking the will, just to prepare a fresh will and appoint fresh executors. In the event that some of the dependents pass on, so you have given them part of your property, but they're no longer around, and you can revoke that will, prepare a fresh one, and now give your property to the existing or the dependents who are now alive. So what then now are our options? What then are our other options? If you're not doing a will, what then are our other options? Number 1, joint ownership. So in Kenya, we have 2 forms of property ownership. We have joint ownership and ownership in common. So joint ownership has for the longest been deemed to be ownership between spouses. But the Land Registration Act was actually amended to remove that requirement that it is strictly between spouses. So, and what happens in joint ownership? In joint ownership of property, and now we're talking about land, or a house, or a mansionette, or an apartment, if you own it jointly with another individual, it means the individual who lives on, the one who succeeds the other one, takes it all. So if one individual passes and it is owned by 2 individuals, the one who is left alive, the one who's alive, takes full ownership of that property. So that's it's an easy way of going about owning property, so that then if you want to bequeath, say, your house in Kiambu to your daughter, you then own it jointly with her. And then when you pass on, she then fully takes over or takes ownership of that property. So that way, we avoid the long route of having to go to court for ownership of that particular property that is jointly owned. I'd mentioned that the other way of owning property is owning in common. Owning in common is where you own in shares. One person owns 50 shares, the other one, in whatever shareholding, one can own 40 and 60, depending on how you have contributed to buy that property. So this is good for business partners, it is good for individuals who have gotten into a joint venture of some sort, so that the one who dies, his family will claim his 60% over that property, and the 40% that is owned by the other individual will remain as that individual's ownership of that property. So it is not recommended for this particular kind of a scenario where you are planning for your estate. If you're planning for your estate, we recommend joint ownership. The other option of distributing your property is distribution, actual distribution. So you then say during your lifetime that this particular property goes to so and so. And during your lifetime, you actually transfer it to that individual. So that way, when you pass on, when the testator passes on, when that particular individual passes on, those properties are already distributed and they're already with the people that you wanted to own those particular properties. So then we avoid probate, we avoid going to court for succession. As you have seen in the estate of the late Mbigwenange, it took 19 years. You don't want your estate to fall under the same circumstance. You can distribute it during your lifetime. And then the cream de la cream of the day is you then set up a lifetime trust. And this is one thing that we highly recommend. And we will now move on into seeing what are then the benefits of a trust, why set up a trust, what is a trust, and all that concerns matters trust. So what is a trust? I believe a good number of us here are trustees. So as trustees, we already know our duty and obligations, especially if we are trustees of pension schemes. So one thing that trustees do is that they have a fiduciary responsibility to the members of that pension scheme. But here we're talking about a trust that is set up by an individual. In the case of trusts set up by individuals, the individual who sets up the trust is known as the settler or the founder. So you as the founder, as a settler, you set up a trust, and a trust is a fiduciary arrangement that allows a trustee or trustees, who can be either individual trustees or corporate trustees, to hold assets on behalf of a beneficiary or beneficiary. So when we talk about a settler setting up a trust and appointing a trustee or trustees, and these trustees can be individual or corporate, it is important to note that the law does not disallow or restrict the form of trustees that you want to appoint to run your trust as an individual. Provides for either individual trustees, as is the case for most pension schemes in Kenya, or corporate trustees, as is also the case for a few pension schemes in Kenya. So you can actually have an individual trustee or a corporate trustee to run and manage that trust on behalf of the settler, that is the individual who sets up the trust, and of the founder. So then I will want to move on to how the outlook of such a trust, how does it look like? So we have the settler, whom I've mentioned is the person who sets up the trust. And then the settler appoints the trustees, who then manage the day-to-day running of the trust. And the trustees manage the day-to-day running of the trust on behalf of the beneficiaries. And then there's another individual called a protector stroke or enforcer. So this notion of protector is actually an international notion. It's not something that we have actually had here in our laws in Kenya, but I think it is something highly commendable. I know a good number of you may be aware that the Trustees Perpetual Succession Act of 1981 is currently being amended. In fact, there's a bill in Parliament. There's a bill in Parliament seeking to amend the Trustees Perpetual Succession Act Amendment Bill of 2021. It is seeking to amend the Trustees Perpetual Succession Act of 1981, and for good reason. So this particular bill does provide for an enforcer, which is something we did not have in the 1981 Act. I think this is something that we have borrowed from international jurisdictions, from out there, from other jurisdictions, and I think it's something highly commendable. So let me say something about the enforcer stroke protector. The enforcer is not a trustee at all. In fact, even when you look at the bill, the enforcer may be appointed. So it is not a requirement that the settler appoints an enforcer. Such an enforcer may be appointed, and what the enforcer does is that he supervises. He looks into the actions of the trustee to see that they are acting within their fiduciary responsibility, they are acting nobly, and they are acting for the benefit of the beneficiaries. So he's a supervisor of some sort that just supervises and has a right. In fact, that particular bill provides that he has a right to access the accounts of the trust. He has a right to access the trust deed of the trust. He has a right to access a whole lot of documents as the enforcer stroke protector. So he looks out for the benefit of the beneficiary. He looks out to ensure that the trust is being administered properly. And so I think this is very commendable to have such an individual as part of your trust. But remember, even the bill does not require it as a mandatory requirement. It's may. A settler may appoint an enforcer. And I think it's something very commendable that we have borrowed from international jurisdictions. And I think it's something that we need to have, especially for such trusts that are formed. For the longest, the 1981 Act did not expressly provide for non-charitable trust. Now, the bill has expressly provided for charitable, non-charitable, and family trust. So now we are no longer grappling in the dark whether indeed such trusts can be formed and incorporated as body corporates. So now the 1981 Act gave liberty or leeway to the minister in charge of the Ministry of Lands, and right now the Cabinet Secretary, to make that decision. So that if you're a family trust, which is not, of course, non-charitable, which is non-charitable, it was at the discretion, or it has been at the discretion of the minister whether to register such a trust. But with this bill, we hope that indeed, once it is passed in Parliament, that now it will be very clear that family trust can be registered without being at the mercy and at the behest of the minister of the day, or the Cabinet Secretary of the day. So let me move on. So the settler is the founder of the trust. And what the settler does is that he transfers all his assets to the trust. And then once he transfers all his assets to the trust, now the trustees take over, running and managing the day-to-day of that particular trust. That is investing the assets, ensuring that they are growing, giving dividends to the beneficiaries. And the settler actually sets up this trust in his lifetime. So this trust can actually be set up in the lifetime of the settler and run and managed during the lifetime of the settler. So that gives the settler the opportunity to see how his assets are being managed by these particular trustees. Of course, he has a lot of say over the day-to-day running, but it is, and once this trust is registered, you know how a trust is registered is that, number one, a trust deed is prepared just the same way we do for pension schemes. So we have a trust deed that is then prepared with the settler being the founder of that particular trust. In there, we'll have the trustees named in that particular deed and the beneficiaries named. So that particular document, which is a trust deed, is then registered with the registrar of documents as a document, because it is a document. Once it is registered as a registrar of documents, that is not where the process ends. And this is very important to note, so that you don't have a trust deed as a settler, you register it with the registrar of documents and imagine that that trust has capacity to own property, or to even for you to transfer property to it. So for you to be able to transfer property as a settler through the trust, that trust needs to be incorporated. And therein comes the Trustees Perpetual Succession Act. So under that particular act, that trust can then be incorporated to become a body corporate. And why is that important? Once it is incorporated to become a body corporate, that trust becomes a separate and distinct entity from the settler. So say the settler has a loan with the Kenya Commercial Bank, and he has transferred some of his assets to the trust, and probably one asset is charged to the bank. And then that asset is sold off, but it does not cater for the entire facility. The bank cannot come now to the trust, because that trust is a separate and distinct entity. They can only follow the settler for other properties that the settler owns. So it is very important to have the settler incorporate the trust, so that trust becomes a body corporate, and it now is a separate, distinct entity away from the settler. And that body corporate manages and runs the assets of the trust through the trustee for the benefit of the beneficiaries and the settler during his lifetime. So what then are the essentials of a trust? As a settler is setting up a trust, what are the key essentials of this particular trust? So certainty of intention. The bill that the Trustees Perpetual Succession Bill, Amendment Bill of 2021, brings out these essentials very clearly. That was not there in the 1981 Act. So one of the things that the settler has got to have very clear in their mind, what is the certainty of intention? So when creating the trust, the words that are used to create that trust must express the intention of setting up the trust. What is the intention of setting up the trust? The intention can be as simple as protecting the assets of the trust, so that the settler transfers his assets to the trust, so that the assets of the trust are protected, are managed, are invested for the benefit of the beneficiaries. So that intention has got to be very clear. Remember, for non-charitable trust, some of them need not even have beneficiaries. That's what the bill says. They may or may not have beneficiaries. So in that case, the intention has got to be very clear when setting up such trusts that are non-charitable in nature. Some of them may not even have beneficiaries, and so the intention has got to be clear. Then certainty of subject matter. The trust property should be specifically defined. So when, in the same way, when you're drafting a will, you've got to list your property. Even when setting up a trust as a settler, you've got to clearly set out what is the trust property. That has got to be clearly set out and provided for. Because what has not been transferred to the trust cannot be presumed to be the trust property. And that can be open to other issues of probate and succession in case because such properties will not have formed part of the trust. So it is very important to know the subject matter. In this case, subject matter is the property. So the trust property should be specifically defined and be able to be identified by the parties involved. It cannot be generally defined. So if we are saying it's a property in Kileleshwa, it has got to be land reference number dash 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 or title number dash 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 in Kileleshwa. And those properties need to be now transferred to the trust so that they are no longer in the settler's name, they are now trust property. And they become trust property because the trust has been incorporated under the Trustees Perpetual Succession Act. So before a trust is incorporated under that act, it cannot own property. So you've got to you've got to incorporate the trust under that particular act, the Trustees Perpetual Succession Act, then transfer the settler's property into the trust. And then certainty of object. There needs to be certainty of the class of beneficiaries of whom the trust is created for. It's got to be very clear who are the beneficiaries. If indeed is a class or a set of beneficiaries, there's got to be very clear who these beneficiaries are and what portion are they getting. In fact, the bill has gone ahead to say that even in determining who the beneficiaries are, you can even determine what milestones have got to be met for these beneficiaries to actually benefit. So say if a beneficiary is 18 years old, as a settler, you can actually say that for the beneficiary A to get a portion of the dividends or benefits that come from the trust, they need to have finished their high school, they need to have done their first degree, they need to have done some college, so that then you have reasons, you have grounds, you have certain milestones that you have put. And that's a right of a settler to put those milestones. And probably that is important so that these beneficiaries have a sense of responsibility, a sense of their own individual achievements before they then get the benefits from the trust. And remember, these trusts exist in perpetuity, not unless it is stated otherwise by the settler during his lifetime. So if the settler has not said that this trust is revocable during his lifetime, it is then presumed that the trust will exist in perpetuity. And that's why it's important to have trustees, and I would recommend actually corporate trustees, because corporate trustees are entities, the likes of Octagon are corporate trustees. These are entities that will live long, many years thereafter. So it's always important to have trustees that can manage these estates or this trust in perpetuity. And we will highly recommend corporate trustees. As settlers, let's look out for corporate trustees who can professionally manage our estates. Professionally manage our estates to ensure these estates don't waste away. They actually grow for the benefit of the beneficiaries and the beneficiaries' children many years to come. So what then are the advantages of setting up a trust? So trusts provide asset protection. And why do I say this? If you are to go with the first options that I had given of joint ownership or distribution or even a will, if you are then to go with that option, if the estate of the settler or the testator is say worth 100 million, and it is then distributed to his 5 children, that estate is no longer worth 100 million. It is now worth 100 million divided by 5. You see, so what the trust does, it protects it provides protection of the asset, so that if the estate is worth that 100 million, that is what is transferred to the trust. And you can imagine investing 100 million or even a part of that in, say, government bonds. The benefits are very high compared to 5 people who have since split their 100 million to invest separately. And then, of course, it limits liability in relation to the settler's personal liability. So that the settler has certain personal liabilities, those personal liabilities are not now heaped onto the trust, because the trust is a separate entity away from the settler. And then trust separate control of an asset from the owner. So if you are then the settler and you then own, say, a hotel, a group of hotels, the trust separates that control of that asset from that particular owner of those particular assets. And so may be useful for protecting the income or assets of the trust for the benefit of the beneficiaries. Because now the asset has moved from the owner, who may incur certain liabilities, and it has moved on to the trust, which then is a separate legal entity. And then ease of management of the settler's estate as compared to the lengthy court succession process. You can imagine where you have not set up a trust, or you don't have, or even have a will. Because even if you have a will, that will has got to be subjected to court, a court process, where the court then determines, one, is it a valid will? Okay, it's a valid will. Was it revoked? It was not revoked. So all that process of court will still take its due process, even in a will, which is a better route than dying without a will. But a trust will not be subjected to the court process, because, as we say, a trust is a separate legal entity registered as such in the Trustees Perpetual Succession Act. So it is not subject to lengthy court processes. It is not subject to the estate of the settler being known out there, because when these matters go to court, they then become, they are then in the public domain. We all get to know what you own, where you owned it. A lot of things that probably you'd never have wanted as the settler to come out into the public domain. Then there's less controversy. It's less controversial in the sense that even if you had 5 wives, all they are is beneficiaries for all intents and purposes. They are just beneficiaries. All they do is to ensure the trustees are doing their job and they're getting their benefits, their dividends from the trust, they annually or quarterly, as you have provided in the trust document. So there's less controversy, there is less exposure of your estate to the public and to the eyes of everyone that you probably not want them to see. And then, of course, you have avoided the lengthy court process. So these are routes that I would definitely recommend for any settler, for any individual who wants to manage their estate. And then your assets are protected. Your estate is protected for longevity. You leave a legacy, actually. Here, with a trust, what you do is you leave a legacy. You leave a legacy. It will always be the trust of so-and-so that runs with, that does that. And even part of your beneficiaries can even be to a donation to a school, or to a children's home, or to a church, so that you also do a worthwhile cause as part of the trust benefits that come out every other year or every other period that you have mentioned in your trust. You want that to be done. So this definitely protects your assets and leaves you a legacy as a settler. So let us look at a case here in Kenya of an individual who had actually set up a trust. And this is the case of the trust, the Njenga Karume Trust. So in this particular matter, the matter was actually filed in court in 2015, and the judgment came out in 2020. So here, what the beneficiaries were challenging is that they were actually saying the trustees are not managing this estate as they should. They are doing some things for their own benefit. They are favoring some beneficiaries to the detriment of some other beneficiaries. And in fact, some of the beneficiaries even wanted the trust to be annulled, to be revoked by court. And this is what the court said. It is the duty of the court. The duty of the court is to uphold and protect trusts, not to destroy them. So the court will not venture into destroying a trust that has been set up by a settler. Unlike a will, which can be challenged if there is a fraud, coercion, if there's a mistake. So trust, the court is saying it is not the duty of the court. The duty of the court is to uphold and protect trust, not to destroy them. It is a function of the court to execute a trust. The function of the court to execute a trust, to see that the trustees do their duty and to protect them if they do it, to direct them if they are in doubt, and if they are wrong, to penalize them. And so here, as a settler, the take home is who are the trustees that you're appointing. In this particular case, the settler, and that is the late Njenga Karume, had actually appointed a family member and a few friends as trustees. So here is where we are recommending the corporate trustee route for professional managing of the estate, of the trust that has been set up by the settler. So this took a shorter period, but it's still 5 years. And what the court ended up saying is that the trustees be replaced. So the appointment and replacement of the trustees to be undertaken in line with the founder's wishes, and that is the settler's wishes. The court found that the remedy was not in the dissolution of the trust or giving the right control of the trust property to the beneficiaries, since that will defeat the founder's intention. You see, the court will not take your property and redistribute it to your beneficiary. The only thing that the court did here was to order for replacement, a change of the trustees who are not managing the estate well. But what are we saying? The assets have been preserved. The estate has been preserved as one whole estate, without it being redistributed, without the trust being dissolved, just the trustees being changed. So it is very important, even as we're setting up this trust, to look into who are we then appointing as our trustees to manage the trust that we have then set up as a settler. So this is very key, and for all intents and purposes, we still recommend trust is the way to go. So what happens when you have property in multi-jurisdictions? So it is important, number one, to list such properties that are in such jurisdictions. And if you're then drafting a will, provide for such properties within your will. If you are setting up the trust, it is important to transfer those properties from your individual name, where they are in those different jurisdictions, into the trust. And then, but you remember, for movable property, if say the property is in Ethiopia, you've got to follow the law of that particular country, even as you want to transfer that property. So you need to look into the laws of different countries as you work at transferring the property, or as you work at bequeathing the property to the particular beneficiaries that you wish to bequeath the property to. But the essence is provide for your entire estate, whether the property is within the jurisdiction or outside the jurisdiction. So estate planning, in a nutshell, now I'm actually in my last set of slides. So create an inventory. So this is just a recap of what we have said. So create an inventory of your assets and your liabilities. Then have an emergency or contingency plan, access to accounts, instruction to executors. So in case you have this will where you have all your assets and liabilities listed, how easily is it to access your bank accounts? What instructions are you giving to executors? Then identify your beneficiaries and dependents, and then provide for them as you would wish. So if you have said, these are my beneficiaries, these are my dependents, if you're preparing a trust, provide for them. Say this beneficiary shall be getting a dividend of 2% or 3% of this amount on an annual or on a biannual or on a monthly basis from my trust. And then same thing goes for every other beneficiary. Provide for them as you wish. If you want them to hit certain milestones, say that they need to have attained ABCD or done ABCD for them to start benefiting. You have that right to provide for in your will or in your trust. But remember, a trust is not subject to court processing. A will is. So that's why we will highly recommend going the trust route. Then, in a nutshell, please protect your assets. You protect your assets by either drafting a will, setting up a trust, joint ownership, or distributing them during your lifetime. Then document your wishes. How to document your wishes is through a will, through a trust. Appoint executors. If you have a will, appoint executors. If you have a trust, appoint trustees, either individual trustees or what we are highly recommending, corporate trustees. So please, as a takeaway, preserve your estate, manage your estate, distribute your estate. Make a will, set up a trust, distribute your property, or have joint ownership. So this is very important. And in fact, in order of priority, should be set up a trust, then make a will as the next. So set up a trust is number one. Then if you've not set up a trust, make a will. If you're not making a will, distribute your property during your lifetime or have joint ownership of your property. Remember, we don't want to fall under the issues, or to be an example at the estate of Buko and Nange, where the judge said, I wish Kenyans would get into the habit of planning their estate. Thank you. That is it for me. Back to you, Nelly.
Thank you so much, Stella. I feel like I've learned so much. I feel like there should be a book. There should be like a book that you're providing to take away all this information. So I thank you so much. Thank you for what you've shared. I believe each and every one of us who has been here today has gotten so much more knowledge because of it. I would like to perhaps see how many questions we have in the chat section. Just a moment. Oh, we have several questions. Let me give Stella a chance to take a sip or two of water and compose herself as she familiarizes herself with the questions in the chat section, and give this opportunity to Mr. Anthony. Mr. Anthony Odhiambo, I want to give him 5 minutes to introduce himself, and then after that we'll do the Q&A. Anthony, over to you.
Thank you so much, Nelly. Thank you so much, Stella, for that wonderful presentation. Good morning, ladies and gentlemen who are actually logged into this webinar. As you've seen in our invitation, this was just, what you've just gotten is just a tip of the iceberg as we look forward to meeting you personally in Naivasha, that is in November 11th to 12th. So please just make sure that that date is kept. But over and above that, my name is Anthony Odhiambo. I'm the General Manager, Octagon Trustee Services, who actually through the courtesy have brought this matter of living legacies instead of poverty. And I want to just to pick it up from where Stella left, in that I don't know what is our fears, ladies and gentlemen, as we are seated here, as we are logged in. Now, what is our real fears, especially so one with issues of writing wills and even setting up trust? Now, Octagon Trustee Services has been in existence since 2008. We are part of the corporate trustee services. That what we do is to offer trust, and that means a big chunk of our funds come from death benefits. And recently, we actually even registered a Hekika trust that will be now talking to you and I, people who are making money now, who can actually have a living trust, so that we can be able to manage our wealth beyond us. And I like the way Stella had put it, in that we need to manage wealth beyond our living. And what a good way to do it through a corporate trust. Through a corporate trust, people who have the wherewithal, have the expertise to ensure that your beneficiaries continue benefiting from your sweat all the through the many years that you've been. I was in a session somewhere, and somebody asked me, why do we not even when we get employed, why is it that we cannot be able to start writing a will by then? With the invent of Corona, where people do not know when and the deaths are actually happening. The key thing, and what we need to be looking at, is how prepared are we, just to ensure that we get to put our act together. So, ladies and gentlemen, I think the key thing here is just to let us know, number one, we must be able to leave legacy, not poverty. as we work through and as we ensure that our life, even beyond our living, is taken care of. Number two is that we must also be in a position to be legends and not a nobody. It pays that 100 years from today, if you manage your life well, then people will actually refer to that person. You know, this person organized himself so well to an extent that we can still see the properties, we can still see the assets, we can see their children and their grandchildren, great-grandchildren benefiting from their sweat. And I'll also want to urge all of us that let's not live an era. Let's live an era where you can be remembered, but don't live in an era. Don't live an era as you die. So, as Octagon trustees, I think the makeup of our funds mostly are retirement benefits, and we've dealt with so many trustees where members of schemes die in service, and their children that the members have left behind. In that case, the law is very clear and gives them that leeway to basically transfer that money into the trust. So if you are a trustee, please just ensure if there's a death case, please talk to us. We also take in SACCO monies because these are monies that are not supposed to form part of the estate. And more so, we also take group life and personal accident benefits. And where you know a family member who could have died and there are dues that are due to them, especially for group life and personal accident, and you believe and know that they have children that might not benefit from those kind of monies, then you can also talk to us. So we are just encouraging, and we are talking to all of us that this is a new area. This is something, wealth management does not just mean that you manage your wealth during your lifetime. You must manage your wealth beyond your life. And that is now through trust management, and corporate trustee and Octagon trustee basically come in handy. So Nelly and the people who are logged in, that's basically what I could say for now. In that, please book your calendar. We will be with you in Naivasha from 11th to 12th of November. And please, we'll talk more, we'll engage more, we'll share life experiences so that as we walk this life, we are walking a life that we are capable and very proud of as we look into the future. Thank you so much. And back to you, Stella, for the questions that are on the chat. Thank you, Nelly.
Okay, thank you, Anthony. Thank you for being brief and straight to the point. I think we'll just go straight into the questions because there are several of them. Literally, the questions started coming in thick and fast. That's what Jeff Fernandez is always saying. They're coming in thick and fast. Immediately, Stella just started speaking. So Stella, if you can unmute yourself, we can start with a question from John Owino. He asked, is there a template for a will, or one has to go to the advocate and start from scratch of writing a will, or when writing a will?
Thank you, Nelly, for that question. Thank you, John, Mr. Owino, for that question. Is there a template for a will? I ordinarily discourage matters template, because in that template, you might miss out some very crucial things. One thing about a good will provide in the last clause or there for any property that has not been provided in the will. We call that a residuary clause. So you may find that you have adopted a template somewhere that lacks that residuary clause. And one will ask, why is a residuary clause important? A residuary clause, just like the word residuary, means balance. Anything that you may not have provided in your will then be provided in that particular clause, because you will say any property, any portion of my property that has not been provided will form part of my residuary and shall be distributed to so and so and so and so. So that then you have your entire assets well provided. Then remember, even amongst your beneficiaries, there is how you may want to share out a particular property. So say the property is 100 acres. You may want to say 10 acres shall remain as a burial site for your children and your children's generation. And then the rest of the acres shall be distributed in this manner. And none of your family members or none of your first generation are allowed to sell, only the second generation going forward. That you may not find in a template. So it's good to custom make your will. It's your will. It's your last will. It's your last desire. Please have it custom made for you as you wish it to provide, as you wish to provide for your beneficiaries in the manner in which you wish to provide for them. You may want to have yourself interred by way of burial at Langata, yet your ethnic community, no one has ever been interred at Langata. So if you don't expressly provide for it and consistently inform your family members, you may find yourself traveling all the way to Bondo to be buried there, whereas your wishes were elsewhere. Probably you want to give your body out for medical research. And I hear such bodies that are bequeathed or given out by an individual for medical research are well taken care of, unlike the ones which are just recovered from and they have no one who's claiming them. Probably that's what you want to do, and no one has ever done that in your entire where you come from, in your entire village. So you've got to custom make your will. That is very, very important.
Okay, thank you. Thank you so much for that. And thank you, John, for your question. Wilbur Naigambi asks, was just saying that the screen was not clear, I think one of the slides. Monica is asking, how come some written wills are invalidated by a court of law later on?
Okay, thank you for that question. Sorry, Wilbur, about that slide. I will be able to share the slide and you'll be able to see the full slide. How come some of the wills, Monica Ayeko, thank you, Monica, for this question, are invalidated? So drafting a will, and that's why we're also saying let's avoid the take-note route, is a very intentional process by the testator. So when you are drafting a will and you have gone through all the provisions, how you want your property and your assets distributed, you have provided for your beneficiaries. So some grounds for invalidation are: one, if the witnesses who witnessed you signing your will, and remember we've said these witnesses are not beneficiaries of the will, if they then say that they actually did not see you sign. In fact, in my, I think, second year in campus, a will was invalidated because a man who was running a shop drafted his will. Then he called one of the people who were actually buying to see him sign. But the gentleman was busy packing off his product he had bought. He actually did not see him sign. So because he did not literally see him sign, that will was invalidated. So your witness has got, the person witnessing you signing the will has got to literally see you sign. We are saying that there have got to be two witnesses. They don't have to be there simultaneously at the same time. But remember, you only sign once. So because we are signing once, it is important that they see you sign, and they can see you sign, but they can witness, they can put their signatures at different times. So they can all be there, see you sign your will, and then one excuses themselves probably to pick a call, one signs and the other one then comes back to sign. But most importantly, they've got to see you as the testator sign off that will. And then the other thing is the beneficiaries. So say you have 2 wives and you have 5 children, and then you provide for the 2 wives and then you leave out, say, 2 of the children. That is actually a ground for invalidating because you've actually discriminated those particular children. If you've taken in, say, your brother's children or your sister's children, and you're living with them, they're your dependents, and you deliberately leave them out, and you've been paying school fees for them. So it is important to provide for those individuals that we were saying are dependents. Before you then go on to provide for schools, you go on to donate money to churches, to children's home, ensure you've provided for all those dependents that had been depending on you during your lifetime. Even a husband who has been depending on you, whom you've been paying school fees for or supporting, is also a dependent. So ensure you provide for all your dependents, ensure the witnesses witness you signing the will. That is very crucial for it not to be challenged. There are a lot of things. Fraud, if there was fraud, if a gun was held to your head and then you gave some property to your mother-in-law, of course you were maintaining her, but you didn't want to give it to her. If that fraud can be established by your children, then that will be challenged. If there was coercion, if you're on your sick bed and a piece of paper was brought and you were told to sign, all those things are grounds for invalidating a will. And that's why some wills end up being invalidated.
Okay, learning so much, Stella. Let's go. John Safiri is asking, how does one make a will for jointly owned assets? And John Owino also asked, who is a 6th degree relative?
Okay, thank you for that, for those 2 questions from John and Mr. Owino. Yeah, so how does one make a will for jointly owned? You don't make in a will, you don't provide for jointly owned. Remember I said there are two forms of ownership. Ownership in common or joint ownership. So in law, joint ownership, when one of the people who owns a property jointly passes on, the other one gets it fully. So if you provide for a jointly owned property, that is an exercise in futility. But if you own the property in common, in shares, in common means you have a certain percentage, then you can provide for it. And then you say for property, say in Kitusuru, I bequeath my share to so and so. So you can actually provide for a property that is owned in common, but it is a nullity to provide for jointly owned. Because remember, jointly owned is a way of distributing your property during your lifetime to avoid succession, to avoid the court process. 6th degree relative. Yeah, so generation, you know, we have generational relatives. So you have your children, that's your first generation, then your children's children, then your children's children. So the 6th degree is where we have gone to your great. If you still be alive to see them, that's what we're talking about, 6th degree relative. Back to you, Nelly. Nelly?
Sorry, it turns out I was talking and I admitted myself. Wango is asking whether for joint ownership, can the owner be a minor, such as a child? And then Christine, all the way in Mary, is asking, can children below the 18 years be owners in a joint ownership? So basically the same question.
Oh, whether minors can be joint owners. So currently it is not possible, because when you are transferring property, one of the requirements is a copy of ID and a copy of PIN. So say you're buying property from me and you want to own it with your child. So you will, once you have finished paying me and then have given me the title to go transfer, the Ministry of Lands will ask for a copy of your ID and a copy of your PIN. So your child may not be having those two documents. So that is not possible at that stage. But when they are of majority age, when they turn 18 years, indeed, you can own property with them jointly through that process of, because then they will be having those particular documents that will enable ownership of property jointly.
Okay, great. Gaudensia is asking, how does one handle a case of joint ownership with a spouse where one spouse is not willing to write a will? You know how our fellow Kenyans feel about writing wills. So how do you deal with that?
Yeah. So you see, a will is very personal to the individual, to the testator. So if your spouse does not have a will and you own a property jointly, number one, remember I've said, when you own a property jointly, you do not need to provide it in your will. Because by the time you are saying you want to own the property jointly, it is very clear in your mind, as clear as day and night, that you want the person who lives to succeed the other one. So you are sure that that house, once you pass on, it will fully belong to your wife. And if your wife passes on, it will fully belong to you. But if you own property in common, so in share, and you can even own property in common with your spouse, the law does not refuse that. You can own it in common. So probably she took a loan and you took a loan and you bought a house and each person brought 50%. So you can then provide in your will that my 50% in this house will go to my mother or will go to my firstborn son. And that is your right. But as you're providing for your mother, ensure you've also provided for your children for other properties. Because if you don't provide for your children, degree of consanguinity, your children have a higher right to inherit from you before your parents. So if it's in common, if it's ownership in common, you provide for your share of the property. If your spouse does not wish to write a will, that is well and good. But as an individual, you will have done your part in terms of distributing your assets during your lifetime. But if it is joint ownership, the other person will succeed you after you're gone.
Okay. We have a question. What's the difference between an enforcer and a trust secretary?
So right now, the enforcer in this particular case is under the Trustees Perpetual Succession Act. Under the Trustees Perpetual Succession Act, Trustees Perpetual Amendment Bill of 2021. That is a bill that has introduced the term enforcer. Remember, this bill or the term enforcer was not introduced for pension schemes. So we've got to move away from pension schemes, where we have a trust secretary. We've got to move away from pension schemes. So this is for individual trust, individuals who set up their own trust. So ideally, such individuals do not have a trust secretary. They only have the trustees and the beneficiary. So the enforcer actually just supervises, and you can actually even say that their role more or less borrows from what a trust secretary does. But they actually have a right to ask questions, to ask why are we investing here, why are we doing here, what are we doing here. But the enforcer cannot be a trustee. Remember, for certain pension schemes, you will find even a trustee is a trust secretary. But an enforcer cannot be a trustee. That is very clear in the bill. The enforcer cannot be a trustee. He's not a trustee. He's not a beneficiary. He's just an independent party who's watching and looking over what the trustees are doing and how the trustees are administering the trust.
Okay, thank you. And then we have about 3 questions from Penina Thairo. She asked, does the family trust have to be registered? How is the trust account operated where there are 2 trustees? What happens in a scenario where the trustees die or they get incapacitated? And also where the settler is deceased but has appointed trustees. Can the trustees set the rules of the trust in terms of eligibility and the beneficiaries? So very serious questions coming in from Penina.
Wow. Thank you, Penina. Does a family trust have to be registered? Yes. You see, we have said a trust has a 2-stage process of registration. Number 1, you register it under the Registration of Documents Act, under RDA. And then number 2, you incorporate it under the Trustees Perpetual Succession Act. So why do we incorporate and why do we register? So number 1, for you to be able to incorporate, you have to have registered. So you cannot incorporate a trust that has not been registered. But then why do we incorporate? We incorporate to make it a legal entity, a corporation, an entity that is separate and distinct from the settler, an entity that can own property in its own name, in the name of the trust. It can own property in the name of the trust. How is the trust account operated where there are 2 trustees? Where there are 2 trustees, the account is operated just like any other account, but in the trust document, I will highly recommend for the settler or the founder to provide the minimum number of trustees. You see, this is not managed, this is not under the Retirement Benefits Act, which provides that the minimum number is 4 and the maximum number of 9. So because that is not, we don't have an act that regulates and tells us what is the minimum number, the trust document has got to say that at any time, the trustees shall not be less than 2, or they shall not be less than 4. The number of trustees shall be these, or the settler has appointed a corporate trustee. So it's either you have a corporate trustee, if you have individual trustees, you then mention what is the minimum number. If the minimum number that the settler indicated in the trust is 2, then the 2 trustees can actually manage the trust, because that is what the trust document says. And then what happens in a scenario where the trustees die and get incapacitated? So the trust document is very crucial because it needs to provide what happens where the trustees die. What is the process and what is the procedure for reappointing or appointing other trustees in the event the trustees die and are incapacitated. So all that has got to be in the body of the document. And this is where we are saying, let us avoid generic templates. Let us come to an advocate, let us structure a document that is well thought out, that helps you think of all scenarios. What if all the 4 trustees were in one car and they all passed on the same day? What happens? And that's why we also recommend corporate trustees, because corporate trustees are not subject to such things as death. Of course, they can be wound up and they can be, that whole procedure of insolvency under the Insolvency Act, because they are companies. But then even the trust document should say, what if the corporate trustee is wound up? What then happens? So then the document clearly provides that the beneficiaries shall have the power to appoint fresh trustees, or the beneficiaries together with the that gentleman that you were saying is not a trustee. That gentleman can come in to help in that process of reappointing, but the trust document has got to say, how do we reappoint? Where the settler is deceased, has appointed trustees. Can the trustees set the rules and terms of eligibility of the beneficiaries? No, 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 no. So the settler in his lifetime needs to provide for everything. The trust document needs to provide eligibility, who's eligible as a beneficiary, what is the eligibility criteria, and even when you are eligible, what benefit do you get? So all that has got to be set out in the settler's lifetime. All the trustees do is a fiduciary responsibility. They action, they effect what the settler, what the founder had stated in that document. That document is not subject to amendment by the trustees. No, 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 no. It is a document that is not revocable, that exists in perpetuity, and that's why that document has got to be well thought out, well crafted, well prepared, so that in the event the settler dies, and we know the settler will set up the trust during his lifetime, but the trust will outlive him. So indeed, at some point the settler will not be there. But even when the settler is not there, the document needs to speak of all circumstances and speak into what the beneficiary's rights are, what their limits are, what the trustees can do. All the trustees are doing is effecting or running the trust as though they were the settler in a fiduciary position for the benefit of the beneficiaries. Yeah, I hope I have answered those three questions.
I'm sure in absolute great detail. As we try and wrap up, hopefully we won't spend too many minutes past it. I'll skip over the questions that have already been answered. So I'll go to Mercy. Is there a handover process, or how do the beneficiaries know that they need to benefit from a trust, and what happens in the instance where the beneficiaries would like to incorporate a more profitable venture for better returns from the trust? So Stella, quickly, short answers as we try to keep time.
How they know? You know, this trust is not set up in secrecy. The settler informs them during his lifetime, so they are fully aware. It is set up during the settler's lifetime, so they are fully aware. It's not a secret that indeed they are beneficiaries.
And then Irene is asking, what happens if a trust founder has signed a personal guarantee with a bank for a loan and is unable to pay? Can the bank dispose the property held in the trust?
You see, no. Okay. So if the property is loaned to the bank, that property cannot, in essence, be transferred to the trust because it has all those issues with the bank. So that the settler cannot transfer that property to the trust until that property is clean. So that means those are the liabilities that the settler will remain to deal with the bank in his lifetime. Once he finishes paying the bank, then the property goes to the trust.
Okay. And then Marie is asking, what are the tax implications for setting up a trust, particularly those that are set up for wealth creation and preservation?
Yes, thank you for that question. I in all honesty, will not want to respond to matters tax. I am no great expert. All we say is that there are definitely tax benefits, a lot of tax benefits in trust as compared to if the settler just holds on to the property, but I will not want to miss the details of that. I don't think I have proper expertise in matters tax.
It's true. I agree, Stella. Irene, I'd say you would be better helped at the main trust workshop. We'll have people who will be touching on the tax implications. Jane is saying, thank you so much. She's learned so much from you. Thanks as well from Florence. We have Calvin, just a moment, who's asking, good morning. Thank you, Stella, for a very insightful presentation. Quick question. A large part of the presentation centered on the amendment bill. How far is it in the legislative process? How far along are we with the bill?
Yes, so how far along with the bill? I have taken liberty to read the bill. I see it has been presented before the legislative, the committee that handles matters legislation. I do not think that it has yet passed that level, so it has not been presented to the plenary of Parliament for adoption. But what we keep hearing when we keep asking out here is that it is actually in very advanced stages. We're actually hoping that it will be out in August. So now in September. So in terms of the exact stage where it is, I'm not too sure. But hopefully before the end of this year, that bill should be announced.
Okay, And then Pamela is asking, can you touch on wills and pension benefits? Do they ever cross?
No, they don't. Pension benefits are not subject to succession. You cannot even provide for them in your will. And even if you provide for them in your will, it is what I'm calling the residuary. Anything that is residuary, that is what, if you had not had, if you're not filled in the beneficiary form with the scheme trustees, that is the only portion of your will that they can rely on, but they don't. Pension is determined, distribution is purely determined by the trustees of a scheme or as per the form that you are filling in.
Okay, and then Bernard is asking, can say something about executors? Can it be a family member, a lawyer, or even a friend?
Yes, it can. Can be an executor, can be a friend, can be a lawyer, can be even a beneficiary, even a family member can be. Even most of the time, people appoint their spouses and one of their children as the executor, but the witnesses are the ones who cannot be beneficiaries.
Okay. A lot of thanks from Collins. Helen is asking if the recording will be available. Yes, it will. Irene is asking whether you will share the presentation. Stella, will you share the presentation?
We meet in Naivasha.
We meet in Naivasha. So Anthony has said we meet in Naivasha. Katerina is asking what happens in the case where husband and wife, no, you've already answered this above, I think. Wycliffe is asking, in the exercise of their fiduciary responsibility, can trustees after nomination of beneficiaries list when they deem it to be necessary in a pension scheme, especially after death of the member? Can they alter a nomination of beneficiaries? Trustees in a trust.
In a pension scheme, here we're talking about a pension scheme, not the individual trust. The beneficiaries is always subject to the trustees' approval. See, when the trustees reject a certain nomination, they've got to put their reasons in writing, knowing very well that those reasons can be challenged before the CEO of RBA or before the tribunal. But yes, they have a right, especially where you have not bequeathed to a child who's even in school and you've been maintaining them. Trustees have some form of belief, but their reasons have got to be documented, very well documented, with good reasons why they've altered that nomination. Or even the beneficiary may have passed on. So trustees do have that power in a pension scheme.
Thorough due diligence.
Yes.
Oh yeah, due diligence. Yeah, they've got to do some due diligence. Number one, check are these beneficiaries even in existence, and number two, has the member who may even have maybe what, who may have left, maybe a deferred member, has he really passed on? They've got to confirm that there's got to be some serious due diligence even before they go into altering, and that's why their reasons have got to be informed by something. They've got the reasons that inform that have got to be in writing.
Okay. And then you have Jackson Omamo who's asking, or rather he's telling us, over time I have witnessed arguments on written wills to the effect that there is no equitable distribution of property or wealth from the deceased. This brings so much litigation as it's been seen in some of the families lately. Does the court have a mandate to share out the benefits equitably to the families, and is it correct to take that direction?
No, the court has no mandate to share equitably. Yeah? You know, we say equity is not equality. So that's a common law doctrine. So there's no obligation on the court or even on the testator to share equitably amongst the beneficiaries. But what the obligation is to provide for all the dependents, especially the ones who fall under the first line of consanguinity. And when I talk about consanguinity, I'm talking about your wife, your children, the people who are depending on you, you've taken in, your parents, in that particular order. The law of succession already provides a particular order. So that degree of consanguinity, provided you've provided for them in your will, not equitable, but you've provided for them, then that is not a ground for challenging a will. Of course, people will challenge, not to say they will not challenge, but most courts will hesitate to invalidate a will on such a ground.
Okay, and then Polycarp is saying, good morning, I've learned a lot from today's session. With the information received, would one say that a trust can be used as a means to avoid division under matrimonial property in the instance of divorce proceedings?
Division under matrimonial property in the instance of divorce proceedings. Yeah, but you see, in the instance of divorce proceedings, if you have transferred a matrimonial property to the trust, that can easily be challenged. And when we're talking about matrimony, you know, you have the Matrimonial Properties Act. which clearly defines what is matrimonial property. So as you are transferring a matrimonial property to a trust, just know that that can be challenged as far as that matrimonial property is concerned. And you know what the courts have been saying over time, even for matrimonial property, you've got to demonstrate that you contributed in obtaining it. They're not just to say it's matrimonial property. So yes, the answer is actually, it can be challenged. It can be challenged. It can be an avenue to try and avoid, but that can be challenged in a court of law, especially for matrimonial property. That is clearly defined as such under the Matrimonial Properties Act.
Okay, and then the last question is from Marilyn Waweru. She asks, if a pension scheme is set up as a trust, then why does a scheme need to transfer beneficiary benefits to a trust aside from the scheme?
Set up, when does transfer benefits to a trust aside from the scheme? So a pension scheme, what happens is that we have a trustee, we have the sponsor or the founder who sets up the trust, that's the employer, and then appoints trustees and prepares a trustee, which is then registered under Registration of Documents Act and RBA, with the RBA, Term and Benefits Authority. But that does not make the trust a body corporate. And that's a myth we need to debunk. Just because you're running a pension scheme that is registered with RBA does not mean that that trust is a body corporate. So if you want for your pension scheme to become a body corporate, and especially now in the advent of the mortgage regulations, where we start giving 40% of accrued benefits to our members to purchase houses from institutions, and then the scheme is supposed to register an encumbrance, it is important that these schemes are registered as body corporates under the Trustees Perpetual Succession Act, so that the scheme is the one placing the encumbrance, not the trustees, the individual trustees in the individual name.
Okay.
The scheme. So I don't know whether I've answered that, but that's what I understood the question to mean.
And just to add on, Stella, I think also, having a death benefits run within a scheme, it is high risk. Number two is that the administration of it, when a member dies or a member leaves the scheme, then the regulation is very clear that there's a timeline on which those benefits need to be transferred somewhere else. So in terms of death benefits, for death benefits, it is only prudent for trustees basically just to separate the scheme that is now for the people who are in employment, the living, from the death benefits. And that's why now transferring those death benefits to trust becomes easier for management, and also now dealing with the beneficiaries separately from the trustees. Remember, also trustees also might have vested interest depending on how they use, because they are also that could have been a former employee to them and how they used to relate. So there could be a mismanagement or skewed way of managing those death benefits. Thank you.
Thank you.
Thank you, Anthony. Thank you, Stella. I think that with that, we come to an end to our question and answer session. And I can see we're quite out of time. You're running almost 10 minutes out of the window that we had for this particular webinar. So my thanks to each and every one of you who is still logged in, everyone who joined in. I hope you have had value. I hope that what you have learned today was something new, something that you didn't know, and something that will go a long way in helping you. I usually say matters, trust, and estate planning. It doesn't just help you, it helps you, because all of us, you go for a matanga somewhere, you go for some sort of, we're always burying people, so it's always important to have this sort of information at your fingertips. Quick takeaways, please note the poster that you have on the screen right now. We have a workshop that's going to be taking place at Sawela Lodge from the 11th to the 12th of November, just 2 days of immersing yourself in trust and understanding exactly how best they can help you, help your organization, and help your scheme. So we will be sending just a simple email, just in case any of you would be interested, and you'll be able to meet Stella in person that particular day and ask her all of the questions that you may not have had an opportunity to ask, as well as having, just a bunch of wisdom and knowledge shared from experts in this particular corner of the industry. So thank you so much. As we exit, you can tell Stella a quick thank you and have a good day to the fellow ladies and gents in this particular meeting, and have a wonderful day. Thank you so much for listening to us, and God bless. Keep safe, everyone. Corona is still here with us. So have a good day. Yes, sir. So if everyone can just give me a quick wave as they exit, so that I also know we are together. I wasn't speaking alone. Tell Stella thank you.
Thank you, Nelly. There was one question.
Thank you, Stella.
There was one question that was not answered. That is on the transfer of property to a trust, whether stamp duty is payable.
Yes.
Yes, it is actually payable. If you're transferring property from the settler to the trust, stamp duty is applicable. But there is a way around that, which is a very legal way. And we can discuss that in Naivasha.
Yes.
Thank you,
So
Stella.
you have seen value for Naivasha. Come find out how to avoid stamp duty. Okay. So thank you, Stella. Thank you so much for your time. Thank you for everyone who's participated. I'm seeing your waves as you exit. Have a lovely day, everybody. Thank you for making the time. You are wonderful. Have a lovely day.
Blessed day.